So Donald Trump is going to be arraigned for a fourth time tomorrow in the state of Georgia. Trump reportedly waiving his right to attend, so he will not be there. But this as a number of groups are trying to have Trump's name removed from ballots across the country on the grounds of the 14th Amendment. This happening, not surprisingly, in blue states. Joining us now for more, attorney Julianne Murray and former Trump impeachment lawyer David Schoen, who represented the former president during his second impeachment, back with us on this Tuesday morning. Great to have you both on. Appreciate you being with us. David, we'll start with you. Take us through what these Democrats in blue states are trying to do. Let's say Trump's the nominee. They could theoretically keep his name off the ballot.
That's their theory. A lot of this is based on a recent law review article in the University of Pennsylvania Law Review by a couple of conservative scholars who make a serious argument. They just happen to be wrong, with all due respect. The 14th Amendment, as you know, Section 3 provides that one who engages in insurrection or rebellion or gives comfort or support to those who do can be barred from holding public office. There's so many problems with, first of all, it's so subject to political partisan abuse. As we see, it denies the right to vote for a candidate of choice, the essence of democratic society, as the court has said. Article 2, Section 1 of the Constitution provides the exclusive qualifications for president. 35 years old, 14 years resident in the United States, American born. There's a statute they're providing for insurrection and the penalty, 18 U.S.C. 2383. The prosecutors have decided not to charge President Trump with that specifically. There's a question whether that even would apply to the president in the first place, in my view. All of this ignores that we had an impeachment trial over this very issue, and that President Trump won that. That was the process in place for that. That's the constitutional process.
You would know, sir. You represented him in that. I'm just wondering. Let me just play you a soundbite. So this is what the left is trying to do. Here's Adam Schiff, of all people, by the way, who lied about Russia for 4 years. This is Adam Schiff, or rather Sunday, talking about using the 14th Amendment to try and keep Trump off ballots. Take a listen.
This is one of the most fundamental questions that could ever be decided under our Constitution, and it will be decided by the Supreme Court of the United States sooner rather than later, and most likely before the first primaries, in which Donald Trump would be put on the ballot or disqualified from the ballot by one of those secretaries of state.
And just imagine, by the way, so Adam Schiff reinforced that. That's a former judge, conservative judge, appointed by Reagan, saying that, Julianne. But let's say this happens, and let's say it happens in an important state, Wisconsin, Pennsylvania, Michigan, states that have gone red and blue in recent elections. Is the Supreme Court going to have to get involved here?
Absolutely. And the problem with this is, I mean, I agree that this is a non-issue. President Trump should not be disqualified under the 14th Amendment. But the problem is the way this is going to play out is in different states. Okay, so state secretaries of state are going to make a unilateral decision to keep President Trump off the ballot in a primary, which is then going to be legally challenged. So there's going to be a bunch of legal activity happening with this. And in order for it to get to the U.S. Supreme Court, it's going to happen in federal court within the states. I mean, so in terms of a constitutional issue, huge, that could play out in lots of different timelines, lots of different states. But I mean, does it look like it's coming? They're certainly trying to gear up for it. I think that it is not a valid legal argument just because a lawyer says that it is. That's, I mean, there are plenty of lawyers that are saying it is not. I happen to be one of them, but this is, the way this plays out is problematic because of all of the different states, particularly, the blue states.
Great point. David, the prosecutors in all 4 of these cases against Trump say they want a speedy trial. Why do you think that is?
I think they want to rush to, first of all, prohibit him from having a proper defense in the case. And secondly, for political purposes. I think it's not coincidental that they were all brought at the same time. I want to just back up 1 second real quickly.
Sure.
Your guest is 100% right. And part of the reason for that was so abusive here is these scholars argue that it should cover a broad range of conduct and indirect support, and that there doesn't need to be a process. We know that's wrong from an 1869 case called Griffin's case, in which they threw this out saying, you have to have a process here. Justice Chase, sitting as a circuit judge in that case said so. He said it's up to Congress to make the proper rules and processes here. We cannot unilaterally deny the voters the right to vote for the candidate of choice.
Good point. Good point. We'll continue to follow it. Appreciate you both breaking that down for us. Julianne Murray, David Schoen, thank you.